Good morning, this is your Kelso Report for Wednesday, May 9th, and I'm your host, Clark Kelso. Well, today we have cases dealing with qualified immunity, victim restitution, arbitration, labor law, and professional licensing. A nice spread of cases. We begin with the Ninth Circuit Court of Appeals, which had a qualified immunity decision. Now, the law of qualified immunity in the context of a suit for damages against a public official is well established. A public official is entitled to qualified immunity unless the facts alleged, taken in the light most favorable to the party asserting the injury, show that the official's conduct violated a constitutional right and the right at issue was clearly established in light of the specific context of the case at the time of the alleged misconduct. Well, in Carl v. City of Mountlake Terrace, the confidential administrative assistant to the chief of police was deposed by subpoena in a civil rights lawsuit brought against the police department and certain high officials within the department. Her testimony was given in her status as a citizen, not as an employee, and the testimony was contrary to the department's interests. Perhaps not surprisingly, shortly thereafter, the assistant chief of police orchestrated her demotion and subsequent discharge. That time she brought her own Section 1983 action against the department and the assistant chief of police, alleging retaliatory discharge and seeking damages. The District Court of Ninth Circuit agreed that it was clearly established in December 2008 that a supervisor cannot retaliate against a public employee for his or her subpoenaed deposition testimony offered as a citizen in the context of a civil rights lawsuit. So the assistant chief of police loses his qualified immunity and now must face further proceedings in the trial court. Our next Ninth Circuit case deals with victim restitution. In Ward v. Chavez, the trial court had ordered immediate payment of $28,000 to the victim without considering whether the defendant had the financial resources to pay restitution immediately. Apparently, the district judge had the expectation that the Bureau of Prisons would work out a payment schedule with the prisoner pursuant to the Inmate Financial Responsibility Program. The Bureau of Prisons did begin collecting restitution, but the prisoner then challenged the legality of the Bureau's actions in a petition for writ of habeas corpus. The Ninth Circuit had previously held that a district court's statutory responsibility to set restitution payment schedules is non-delegable, and the panel in Ward held that where the sentencing court has failed to consider whether the defendant has the financial resources to pay restitution immediately, ordering immediate payment in effect impermissibly delegates to the Bureau the court's obligation to set a payment schedule. As a result, the district court's restitution order in this case was unlawful, and the Bureau had no legal authority to collect restitution from the prisoner. Next, we turn to an arbitration case under California Court of Appeals. The plaintiffs in Samaniego v. Empire Today had filed a putative class action against a national carpet and flooring business challenging the defendant's allegedly unlawful misclassification of its carpet installers, including the plaintiffs, as independent contractors. The complaint alleged numerous labor code violations that were related to that misclassification. The defendant invoked a contractual arbitration clause which the plaintiffs had signed as part of being retained by the defendant. Well, the First District held that the arbitration clause in this case was unconscionable and unenforceable. The clause appeared at the end of an 11-page, densely worded and single-spaced contract that was in English only, and the contract did not include a copy of the American Arbitration Association rules, pursuant to which arbitration was supposed to be conducted. The plaintiffs were given 24 hours to review, sign, and return the contracts, which were offered on a take-it-or-leave-it basis. And to top it off, the plaintiffs had limited fluency in English. Given all these circumstances, the court easily found the contract to be procedurally unconscionable. As for substantive unconscionability, the contract purported to shorten statutory limitation periods from 3 to 4 years down to 6 months, including for claims brought by employees under the Labor Code. And it contained a one-way attorney's fees provision favoring the defendant. In addition, the agreement exempted from arbitration claims typically brought by employers, namely those seeking declaratory and preliminary injunctive relief to protect the defendant's proprietary information, while restricting to arbitration any and all claims employees might bring. Well, given the one-sided nature of these provisions, the court easily concluded the clause was substantively unconscionable. Now, as you know from our prior reports on arbitration decisions in California, it sometimes appears the state courts are creating special rules to strike down arbitration clauses, really contrary to federal policy. But this is not one of those cases. The First District's opinion here shows how to strike down an unfair arbitration clause under the state's arbitration-neutral doctrine of unconscionability. Next, a labor law case. The plaintiffs in Alexic versus 7-Eleven, individually and on behalf of a class of those similarly situated, sued defendant 7-Eleven under California's unfair competition law, alleging that 7-Eleven, which provides payroll services to its franchisees, unlawfully underpays employees by converting any partial hour worked in a pay period from minutes to hundredths of an hour, which, by virtue of rounding errors, sometimes shorts employees a few seconds of time and commensurate pay. Well, unfortunately for the plaintiff, the complaint did not identify or even cite any specific statutes in the Labor Code as having been violated. And the unlawfulness prong of the unfair competition law requires that some other law have been violated in order to trigger unfair competition law remedies. So the complaint did not adequately state a claim under the unfair competition law. But even more fundamentally, since that particular error could be remedied by amendment, plaintiffs had sued the wrong entity. 7-Eleven does not employ the plaintiffs, and the relevant labor code provisions apply only to the employer and not to an entity that performs the largely ministerial task of providing payroll services. So the Fourth District affirmed the Superior Court's dismissal of the plaintiff's complaint. They need to sue their employer, the franchisee, not the franchisor who was providing payroll services. Next, a professional licensing case. As a general matter, unprofessional conduct that is used as a basis for revoking or suspending a professional license must demonstrate an unfitness to practice the profession if the disciplinary action is to comport with due process. Well, Business and Professions Code Section 2762 provides that a licensed nurse engages in unprofessional conduct when he or she uses alcoholic beverages, quote, to an extent or in a manner dangerous or injurious to himself or herself, any other person, or the public, close quote, or is convicted of a criminal offense involving the consumption of alcohol. In Sulla versus Board of Registered Nursing, the First District upheld a discipline imposed by the board upon a nurse who was convicted of a misdemeanor after he caused a single-car accident while driving with a blood alcohol level in excess of the legal limit. The court rejected the nurse's argument that the drinking, accident, and conviction were not substantially related to the qualifications, functions, or duties of a nurse. As the court noted, the legislature could reasonably determine that any use of alcohol that results in a conviction of a criminal offense, or which is so extensive as to be dangerous to the licensee or the public, is necessarily related to the qualifications, functions, or duties of a nurse. In essence, that degree of alcohol abuse poses risks to patients and therefore justifies discipline by the board. You want to know that your doctor and your nurse isn't high on alcohol or drugs. And that's it for today's Kelso Report. Have a great day in the law.